Hello everyone. Welcome to the Climate Litigation Accelerator's latest webinar of our monthly series. My name is Melina De Bona. I'm a CLX attorney, and today I have the pleasure to be discussing with you the climate rule of law, advancements in climate law from the Hawai'i Electric Light Company case. As per usual, this is a public webinar and it'll be followed by a closed-door meeting of the CLX community of practice. If you're already in our community of practice, please use a separate Zoom link on the email invitation for this webinar to access the community of practice session after this. If you're not part of the community of practice, but you would like to join, please do email the email address provided in the email invitation for this webinar. On a separate note, we are posting a link to the annual CLX survey in the chat box right now. If you could please take a few minutes at the end of this webinar to fill it out, so that CLX can continue offering helpful information and helpful content for you, the climate legal action field, that would be very much appreciated. So let's get started with today's webinar. Today, we're thrilled to be joined by Michael Wilson and Julia Olson. Michael Wilson just retired from the Hawai'i Supreme Court, where he served as a justice for 9 years. Prior to joining the Hawai'i Supreme Court, Justice Wilson served as a circuit court judge of the First Circuit for over a decade. He's a founding member of the Global Judicial Institute on the Environment, and prior to his appointment as a circuit court judge, he was the director of the Department of Land and Natural Resources, the chair of the Board of Land and Natural Resources, chair of the State Water Commission, and the trustee of the Kaho'olawe Island Reserve Commission. Of course, he sat on the case in question today, and he wrote a key and emphatic concurring opinion, which we hope to discuss today. Julia Olson is Executive Director and the Chief Legal Counsel at Our Children's Trust. Julia founded Our Children's Trust in 2010 to lead a strategic legal campaign on behalf of youth for climate action that respects the lives and the well-being of children and, of course, the future generations. At OCT, Julia leads the Juliana versus the United States case. Julia and OCT are the recipients of the Rose Walters Prize for Global Environmental Activism, and she has also received the Curry Rydberg Award for Environmental Activism in 2017, and is a member of Rachel's Network Circle of Advisors. So quite a bit of achievements for both of our guests today. So before launching in, I just want to point out that this will be a discussion, a Q&A session between me and the guests today, and it will be followed by a Q&A with the audience. So as you're listening, if you come up with any questions that you would like to ask them, please do submit them through a Q&A box at the bottom bar. So let's get started. So the first thing we're going to talk about, I would want to point first that if you don't know much of the details of the case, Hawai'i Electric Light Company, please do find a link in the chat to our CLX toolkit. So the CLX toolkit is meant to be a source, an open source for you to use for education purposes or strategic purposes, and it has been successfully used to train students and judges, etc. We compose case studies where we filter the most important aspects of a case. So we have put it there. But in the meantime, so that you're all not distracted reading, we wanted to ask Judge Wilson today if you could provide a brief overview of the recent ruling handed down by the Hawai'i Supreme Court. We're aware that it has quite a bit of procedural history that goes back and forth. So perhaps if you could focus on the primary substantive components of it for today's conversation, that would be wonderful. And I'll leave it up to you, Judge Wilson.
All right, well, welcome everybody. This is an exciting opportunity to talk about this case that is now being discussed in the context of Hawaii anyways, as the most important climate case in the United States. And that's a way of introducing the nature of the case in terms of its ability to affect the future, perhaps in a way that's consistent with the rule of law and the duties of judges to apply the rule of law. So substantively, it's a pretty straightforward proposition in this case that's being discussed by the court, which is whether or not a particular type of energy system, in this case, the burning of trees, should be approved to provide electricity. And it's an issue that was addressed from a regulatory point of view by our Public Utilities Commission, and they decided to reject the project under an analysis that was, I would consider enlightened because they looked at the question in terms of its effect on global warming. The issues that arose had to do with whether under the Constitution there was a constitutional right that could be best described as a right to a life-sustaining climate and a life-sustaining, if you will, environmental system. And our court had already alluded to that in a footnote in a prior case. But in this case, the majority, and I should say the unanimous court, affirmed that there is a right to a life-sustaining climate, and did so under the provision of our Constitution, which is a provision that provides for a right to a clean and healthy environment. I'm sure the audience understands it, that although that is a very appropriate and relevant constitutional priority, it isn't one that's identified in most constitutions in the United States, because most constitutions are older than that issue, the issue of whether there's a right to a clean and healthy environment. So that issue was addressed in a way that was focused on the provision of the Constitution I just mentioned. So it wasn't necessary really for the unanimous court to find a right to a life-sustaining climate under any other provision of the Constitution. However, it is, I think, straightforward that other provisions of our Constitution that are analogous to most constitutional provisions in most states, namely the right to due process and the constitutional right of due process that also subsumes a public trust duty. We have a analysis that has been discussed in Hawaii for some time, that the right to a life-sustaining climate arises from those provisions of the Constitution, the due process clause of the Constitution, as well as the provision of our Constitution that says that there is a duty on the part of the court to preserve resources in a manner that's consistent with their sustainability and to protect future generations. And that's what the concurrence was about. Finally, I'll say that it's important to put into context that we have an emergency in Hawaii, and that's how the opinion, my concurrence begins, just to make sure that we do have a context that's realistic. You know, the judges around the world are having difficulty because they don't come from a background of concern about the environment. They don't come from a background in which the rule of law from an environmental point of view has been developed during the course of their personal practices. So it is useful to emphasize the nature of this threat, this existential sui generis threat, so that it's an opening for judges to start feeling more comfortable with legal analysis. Because if you've been a judge for long, at some point you have to deal with the concept of an emergency when requests are being made to you, for example, for temporary restraining orders, for permanent injunctions. Those are based on an emergency analysis. So from that point of view, I think it's helpful to think about the fact that we have an unprecedented emergency here, because it makes it more comfortable for judges to understand they have a duty to respond to such an extreme emergency. So I'll end there with my long-winded summary, but again, thank you, Melina and Jackie, for your work.
That was perfect.
Julia, would you like to add something?
Yeah, that was a great way to launch us off, Mike. And so first, I think the significance of the majority opinion and Justice Wilson's concurrence is just to put the umbrella on it. Hawaii has been a leader in law in many respects. It is a newer constitution, as Justice Wilson indicated, and as such, it has codified rights that are implied in constitutions across the country and the world, but weren't made explicit because the threats weren't known at the time that those older constitutions were codified. And not only that, but Hawaii's Supreme Court has long been a leader, even before Justice Wilson sat on the bench. in terms of, if you look at same-sex marriage and the right to marry, that court has led our country. And so the fact that the Hawai'i Supreme Court has rendered this really transformative opinion is going to set the path for other courts and judges across the country. And I think in addition to that, like, this is, the ball's rolling now, right? And it's not going to pull back. And there are 4 really important points about the case I want to make and the opinions. One is the recognition of the climate right, the life-sustaining climate right. Really important to have Supreme Courts declaring that right. And that will be persuasive authority in other jurisdictions. And then, of course, it will be binding on the lower courts in Hawaii, where we have a case pending, and we'll talk about that. But also, it's not that the climate right exists, but it must be enforced. And it needs to apply to any cases that are threatening to cause more harm to that right. The third piece is the manageable standards involved in protecting that right. So a lot of courts and judges have concern about, well, it's such a big problem, it's global in nature, what role do we play? And I think the fact that the court was willing to look at a single power plant, energy production plant, and look at the emissions coming from that plant, and still look at the evidence, look at the Public Utility Commission's findings, and review that and say, no, we're going to uphold that decision because this was protecting this most fundamental right. Justice Wilson, of course, goes further to really talk about the science, which is key to informing a standard that protects the right. And so identifying that the 350 parts per million of atmospheric carbon dioxide is a judicially manageable standard, and that courts need to be looking at that because that's what's really necessary to protect the climate right, is really critical and important. And then I think just the other point that these opinions make is the old ways of doing things is no longer good enough. And as Justice Wilson says, this is a climate emergency. When you have emergencies, it raises special circumstances, and it justifies judges really looking for the ways they can use their equitable authority to address the crisis. And that's what responsible judging is all about, is where there's a wrong, where there's a violation and a breach of such a basic human right, there needs to be a remedy. And it's up to courts to look to how those remedies can be formulated. So really important decision.
Very important, very much so. And thank you, both of you, for emphasizing the key aspects of the case. So Julia, my question for you was going to be, from the perspective of a climate litigator, why is this case important? Which I think you kind of answered already, but I want to give you the freedom to add anything. So from a very practical and strategic point of view, for those of us practitioners listening in, what would you tell them in terms of how they can use this decision, if you know already?
Yeah, I mean, some of the things I just said are really important, but I can bring it down to the practical level of, we have a case in Hawaii. It's called Navahine versus the Hawaii Department of Transportation. And the case is challenging the transportation system in Hawaii and how it's being managed and conducted by the state. And we just got the latest reports from the agencies in Hawaii that track climate pollution, and the transportation system emissions have just gone up again. And so I think, one thing for practitioners to recognize is climate crisis is not necessarily a policy problem, because Hawaii, for example, has some of the strongest laws on the books about reducing pollution to levels that will protect Hawaii, and to get to zero by about 2045. And this is also not a technology problem. This is fundamentally a lack of planning and accountability and holding government responsible. And so the Navahine case is taking to task the Department of Transportation, like, you are a lead in terms of decarbonizing transportation in Hawaii. And we need the court's assistance to really oversee, to declare that what they're doing currently is unconstitutional, and to help oversee a process by which the state comes into compliance with the great policies it has on the books and the Hawaii Constitution. And so I think this opinion, and I'll shorten it, the Helco case, is really critical because it does show that courts have the capacity to look at a project, to look at a system, and really hear the facts and decide whether there's been an ongoing violation of these important rights. So that's just one example of how the strong Declaration of Rights in the Supreme Court's opinion assists us in that case. And we can talk about other cases as well as we go forward.
Sounds great. Wonderful. Thank you very much. So back to Judge Wilson. Can you expand a bit on the concept of the climate rule of law, which you developed quite a bit in your concurring opinion, and tell us a bit about it, explain what it is and what you think about it?
Well, the rule of law is a familiar idea to, I think, most judges. And I look at it from the point of view of a judge, because hopefully what's taking place is the application of the rule of law will now become a familiar way to be able to protect this set of rights that you could call climate rights. So with respect to the rule of law, I think it's been often said by academics, and at times a judge perhaps that's had a chance to deal with larger policy issues would agree that the rule of law is the most powerful tool for civilization to be able to maintain peace, and if you will, to have a system of rules that provide justice. So basically, the rule of law can't be overemphasized in the sense that it is a kind of positive force for justice that would transcend, any weapon you can imagine. It's applied right now in a robust way internationally. Usually we think of the rule of law in terms of other constitutional rights because they're more familiar, or business rights, the rule of law that holds together the international economy. Now we have this concept of climate rights. As I say, it's relatively new. In some ways you could equate it to the development of different human rights. The idea that, for example, there was a human right at issue with respect to slavery was not considered to be appropriate or reasonable or applicable initially in the United States. The idea that there were equal rights that pertain to women, the same thing. It was not a familiar right, and it certainly didn't make sense in the context of the industrial era in the United States. So there are times when the rule of law is applied in a way that you could say is new. In the sense of slavery, it was new to say you don't buy and sell human beings. In the sense of women, it was new to say that women would have the capacity to be able to participate in an equal capacity within the context of our economy. And now we accept those as concepts of the rule of law that we equate to human rights as being fundamental. The climate rule of law is a rule of law that is, although new, it's more important perhaps than all the others, because, and this rings true throughout the work that Julia Olson has done and other great legal thinkers like Mary Wood, you really can't have human rights that have to do with equal protection, or human rights that have to do with privacy, or whatever these kind of human-centered human rights are. You can't really have them if you don't have an environment that allows for life, life in a way that I guess you could say is consistent with having an international economy, or consistent with having a sense of justice in which we treat each other with dignity, and in which decisions aren't made purely based on force, or purely through the use of military strength. A lot's at stake, therefore, when it comes to climate rights, and the recognition of the rights has an extreme component to it that's unprecedented in the law, that is an extreme component from the point of view of future generations, maybe if you're 40 years old or young. And what's that extreme component? Unlike these other rights that had a time to develop, rights in which we came to our senses and realized you shouldn't buy and sell human beings, or came to our senses and realized that, for example, it was legal to apply laws to protect children working in factories or to treat women equally. Those are rights that we had a lot of time to work out. How much time do we have if you consider to be the climate rule of law to be science-based? If you want to tell the truth, maybe less than a decade for sure. So this evolution of rights that would be best described as climate rights is paramount in terms of the duties of judges throughout the world. There's no more important duty, because whether you're just interested in the economy or you're interested in a sense of justice, which is the concept, I guess, that's often discussed in terms of trying to improve the conditions of those that are the subject of oppression, or the people that are disadvantaged as a result of unequal treatment in our world community. If you believe in those principles, then everything is sort of hanging in the balance for the solution horizon. By solution horizon, I'm referring to maybe a decade in which we have an opportunity to really apply the solutions. And who's supposed to apply the solutions? We have different branches of the political systems, right? In at least our democracies, we have the different branches of government, whether it's executive, legislative, or judicial. And here we're focusing on the judicial, which still is a very significant power within our political, within the governance systems that we have in politically throughout the world. And to some extent, it continues to be, a robust and applicable system, but the strength of it will start declining very likely if we don't come to a solution of the climate problem within this solution horizon. So that's what I would characterize the climate rule of law to be. It's a way now of making clear that there are fundamental human rights that are involved in protecting the environment, and that they should be applied consistent with the tools that we've developed in the judicial form of government.
Perfect. Thank you, Judge. And so turning it to Julia, how do you think this concept of the climate rule of law that was very well explained by Judge Wilson can be applied to other relevant cases, particularly in the US or beyond, if you have already seen it be applied?
Yeah, I think it's going to be applied frequently and often in cases coming up. And like, before I go into some of that in more detail, I think just to pick up off of what Justice Wilson was saying, the climate rule of law is, we establish rules of law to help us self-govern and also to really protect the things we value as humans. And the work we do at Our Children's Trust is centered around the fact that we value children. We value their lives and their ability to grow up safely and with opportunity. We value the home planet and having it be a place that lives on in perpetuity for future generations in a sustainable manner. And we value human rights and, protecting people equally, not just today, but across time, or equitably at least. And so the climate rule of law does all of that, right? It protects children if it's applied faithfully. It protects the home planet that all species and life depends upon. And it protects intergenerational justice and human rights across the board. And importantly, and Justice Wilson, you identify this in your concurrence, that children are especially vulnerable, as are Indigenous peoples around the world. They are frontline communities that will be most harmed by the failure to address the crisis and the failure, if courts fail to provide remedies for these breaches of fundamental rights and the rule of law that we're talking about. And so I think the big challenge right now is bringing cases before courts with this climate rule of law and having them really educating courts. It is a process of educating judges in this new area of law. You know, the need to take old principles like the public trust doctrine, to take old principles like substantive due process or equal protection, and apply them, those legal rights and principles, to an entirely new set of facts. And that requires heeding the science, bringing in expert testimony into courtrooms, really paying attention to what's going on. And judges have the tools to do this. They do this in many other complex areas of law. I mean, when I think about patent law, it makes my head spin. The level of complexity that judges deal with all the time in cases and novel factual scenarios that arise. But this one is very time sensitive and critical. So this climate rule of law, it is developing around the world. The US courts have actually been slow to really dig in and embrace it, because courts have tended to want to shut litigants out of the courtroom and say that they don't have standing because the problem's just too big. And in 2016, it was Judge Ann Aiken of the federal court in Oregon who was really the first to say that there is this right to a life-sustaining climate system. And that remarkable landmark ruling in 2016 in the Juliana case lit a fire, and globally, a lot of courts have picked that up. Now it's landing, thanks in part to the Hawai'i Supreme Court. It's really landing and taking roots in the United States. And so one case that this climate rule of law is going to be developing in is in our Children's Trust Montana case, Held versus Montana. It will be the first constitutional climate case on behalf of children to go to trial ever in the United States. And the importance of that is that it is really at trial when all the facts can be presented and this expert testimony can come out, and that can really help courts build on and articulate the climate rule of law and how these rights need to be protected, what the evidence is in support of that, and what the proper remedy is going forward. So I think these cases, they can't be decided in a vacuum. They need to have the evidence brought forward. And then I think we can get to like the quick decisions in the next decade that Justice Wilson is talking about that we need, because there is a time-sensitive nature around this. And if courts act in sort of the slower traditional ways that courts like to act, we will run out of time. So the urgency of the climate rule of law is really central.
Great, thank you. And so now going back to Judge Wilson and focusing a bit more on a specific topic that we see more and more come up for those of us that practice, especially when it comes to corporate accountability practice. The case brings up, because of some of the promises by the company in question, the idea of carbon offsetting. So broadly speaking, for those that don't know what carbon offsetting is, it refers to a reduction of greenhouse gas emissions or an increase in carbon storage by, for example, planting trees that is used to compensate for emissions that occur elsewhere. So Judge Wilson, can you explain how the court dealt with the carbon offsetting issue in this case?
Yes, it's useful to think of carbon offsetting as an opportunity for smoke and mirrors. The solutions that are proposed for a very, very expensive injury are solutions that can be seen, particularly in the context of a climate case, as a way to minimize perhaps the economic consequences or the economic damage that can take place when there has been a ruling of a violation of climate rights. there's a bit of a useful analogy here in this Helco case, because the contention of the party, the third party that was proposing a power plant that would burn trees, was that they would offset the carbon from the plant, because the burning of the trees, of course, creates carbon, and it creates carbon at a significant level that, depending on how you look at it, could be the equivalent of burning coal or oil. So the proposition of the company that sought to have the public invest in their power plant was that they would plant trees. So once the concept of planting trees is being discussed as a way to make up for the carbon that's being burned, in this case, the carbon from the trees, once the idea of planting trees is being discussed, it, I think, is useful to keep in mind that the experience of, for example, markets that are dealing with ESGs or dealing with financial instruments that theoretically are supposed to help the climate, you know, those ESGs are often based on an operation that has to do with planting trees in order to make up for whatever kind of carbon production is taking place on the part of the carbon producer, such as an airline company or a company that's mining coal. And you will see that this area is very much defined by false promises, and where there is actually a follow-up, a meaningful type of implementation that involves planting trees, an ineffective operation that doesn't go to the scale that's proposed, you know, and actually having the trees grow in the numbers that they're supposed to in a context of having sufficient health to draw down the carbon. So a carbon offset was seen in this case as a bit of a speculative proposition, because it wasn't clear where the trees were going to be planted. I mean, so many trees had to be planted that it wouldn't necessarily be the case they'd be planted in Hawaii. So the idea was to work with a company that plants trees somewhere else. And the rightfully so, the PUC took a responsible position, which was, well, you don't really have what would be considered a reasonable and dependable plan for how these trees are going to be planted. I think that it's also a measure of, or a test of, a regulatory agency, the extent to which they engage in pretend law or pretend facts. In other words, the agency knows that it's really not possible for them, if, for example, they had a fiduciary duty to shareholders, if they had a fiduciary duty to the shareholders that was based on planting hundreds of thousands of trees, and it turned out that the board of directors or the CEO went along with a plan in which it was pretty clear that you don't know that the trees are going to be planted, you'd be violating your fiduciary duty. If you're a government regulatory group that's captured by the special interest, then you don't necessarily base your decision based on a fiduciary duty. It comes more from a political point of view, where maybe you just want to be able to favor the investors who are particularly well connected, or particularly I guess you could say powerful in a community. This was a huge project, and it tested the political system and tested our regulatory agency, and they acted with a fiduciary duty. You could say a fiduciary duty that would be an anchor aspect of the public trust analysis. You have the regulatory agencies, particularly these days of dwindling public resources, have a great responsibility to apply their public trust duty to resources. And so the smoke and mirrors that sometimes are associated with the idea of carbon offsetting are the smoke and mirrors that are supposed to be seen, recognized, and rejected by the regulatory agencies that theoretically represent the public interest. And in this case, the PUC did represent the public interest.
Wonderful. Thank you, Judge Wilson. And I think it was also very interesting to see the temporal component of the carbon offsetting promises, right? That it seemed that the effort was to be so big that perhaps by the time that the trees actually had any effect on the emissions, it would be too late. And given Hawaii's statutory duties to become carbon neutral at some point. So it's really interesting to see how these promises may in fact be speculative, like the court recognized in this case. So Julia, I'll turn to you with this issue of carbon offsetting in the sense of how do you see this being applied both in the United States, but also abroad, before turning to the questions from the public. Thank you very much.
Yeah, I mean, I think, again, it goes back to science and expert testimony, because the science can cut through the smoke and mirrors. And we're at a point in time where the scientists say that every ton matters. You know, the International Panel on Climate Change, Intergovernmental Panel on Climate Change, and scientists across the world say every ton matters. And that is a theme in our cases. And so each new infrastructure project that will cause more pollution that is leading to climate change needs to be looked at through that lens of every ton matters. And what we do in our litigation, and what I think lawyers and litigants should consider in all of these cases, is really advocating that there need to be two ledgers, right? So you need to have your emission ledger, what is going to come out of a project that's being reviewed in court, the pollution coming out, and then carbon sequestration or carbon drawdown, you know, using the natural sinks of the planet to draw down extra carbon dioxide, that cannot be used to offset ongoing pollution. And here's why. We are at 419 parts per million of carbon dioxide in the atmosphere. And the uppermost safe level to protect human rights and this climate rule of law is 350 parts per million. So we're already in breach. And we need our natural systems like our forests and trees and our wetlands and oceans. We need all of those things protected so they can help draw down that extra carbon dioxide that's already in the atmosphere and has been, right? And so every ton that we're putting up makes it harder for our natural systems to help draw down that extra. So, you know, the bottom line is experts say, like, we can't have new fossil fuel infrastructure. We can't have new projects that are leading to those emissions. And the concept of offset just really has no place in a true climate rule of law. But it's happening around the world. I mean, even the Biden administration, through the Inflation Reduction Act and rules being proposed by EPA, are allowing companies to sort of look at sequestration as a means of offsetting ongoing pollution and ongoing use of fossil. And, you know, Europe allows a lot of offsets, and it is smoke and mirrors, and there's double counting that happens. And so I think the rule of law needs to separate those two columns. You know, sequestration cannot be used to say that your pollution doesn't matter. Your pollution matters, every ton matters. And that's how we need to apply the rule of law on a global scale.
Wonderful. Thank you very much. So thank you both for answering my questions. I think we'll turn it now to the audience who have some questions for both of you in the last about 10 minutes that we have left. So the first question comes from Ellie Happel, and she says, I hear Michael speaking to the rule of law and civilization. I would like to hear him speak about the indigenous ways of knowing, particularly in the climate context, and how that can guide the progress on climate rule of law. Is there a conflict there? And Julia, of course, feel free to jump in if you have any ideas. So this question is game for both of you.
Yeah, thank you for that question. It is something that has a bit of a powerful effect on me. You know, we have an indigenous population that is under siege, might be a way to describe it in Hawaii, but it's not under siege in the way that indigenous people are so many places in the world where you have, for example, environmental defenders being killed at the rate of 3 a week. You know, an environmental defender is a legal term that's applied by the United Nations to describe those who stand up for environmental rights, in particular indigenous homelands. And the idea of learning from indigenous people is so important that, for example, I flew to Peru to help the village of Edwin Chota, who is a wonderful leader of his indigenous community, who was murdered in a very overt way by a company that was illegally harvesting the sacred, and it was a mahogany forest, but a sacred forest of Edwin Chota's people. And the importance of Peru doing that, the indigenous people in the Amazon and their leader, Edwin Chota, can't be overestimated in relation to Hawaii, because if they're protecting these magnificent living things and they know how to do it, and they're even willing to sacrifice their life, the indigenous people in Peru give inspiration to indigenous people in Hawaii that are interested in also protecting some of our critical natural resources that are carbon sinks that maintain the health of the ocean, like coral. The other thing about it is that it provides a kind of opportunity for a straightforward application of the rule of law using indigenous knowledge. Because let's say, for example, there was a climate case that was brought in the area that was so important to Edwin Chota's community, then you would have experts testify from an indigenous point of view. And they would talk about not just the science. I mean, their way of life, I think, makes the point about the science, right? Because there is a way of life that's healthy if it's consistent with maintaining a natural ecosystem, but it's more than that. And our fabric of civilization depends on more than just making sure that we have a scientific system that takes sufficient carbon out of the air so that the earth doesn't heat up. You can have a cultural system that's horribly oppressive and have an atmosphere that's being protected through nature-based solutions, right? So you can't leave out the importance of indigenous people adding to humanity, because it's a framework that says that, you know, human beings have a spiritual self, or human beings have a connection that is a much more intangible one, but in some ways even more important to the environment that sustains them, not just in terms of food security, but sustains them in terms of natural beauty, in terms of the things that humans celebrate together that have to do with the magnificence of animals and plants around us, you know. And so I do think that we're not going to be able to solve this problem. Barack Obama has said as much many times. We're not going to be able to solve this problem purely through science. We do have to solve it as well through justice and the human spirit. And the indigenous people of this world, many of them are so committed to the aspect of their relationship with nature that they're giving their life to do so. And the rule of law absolutely has to protect them, because murder can't be used as a method under the law to deprive indigenous people of their homelands and to deprive the world community of this magnificent connection that we have in terms of our relationship as human beings to the planet.
Yeah, can I add on to that, Melina? I think that's absolutely right. And actually, it was, for me, this transition from doing environmental statutory law in the United States to now representing children and thinking of myself as a human rights lawyer, that epiphany for me really came from talking to international lawyers and indigenous lawyers who were representing indigenous communities. And to them, there was no separation between this concept of an environmental right or a human right. You know, it was one and the same. And I think we can learn so much from that indigenous knowledge. And so I think when we think of a climate rule of law, it absolutely has to reflect and incorporate indigenous traditions and knowledge as a way of articulating the rule and enforcing it. And it's why in almost all of the cases that our Children's Trust brings on behalf of youth, we exclusively represent youth, but we represent Native and Indigenous youth. And in our Hawaii case and our Montana cases, part of the evidence that will come forward at trial is not just the personal stories of the young people who are Indigenous who are being harmed, which brings forth like how significant this crisis is, but also the Indigenous experts who will talk about, what it means at a deeper level to lose this type of climate right. So absolutely critical to these cases.
Wonderful. Thank you both. And so we have a number of questions for you. I think I will ask one more, and if we can take care of it in the next 5 minutes, that would be great. So we can move on to our closed door discussion with the community of practice, where we can discuss the rest of the questions. So this question comes from Nick Flynn, and it says, how receptive do you think judges are globally to those rights and duties on this decade time scale? So I imagine that he's talking about the climate rule of law and how receptive judges may be, both in the US and perhaps abroad. I know that Judge Wilson had quite a bit to say in the concurring opinion about the US compared to other global jurisdictions. So happy to hear from both of you on that.
Thank you for that question. And it's really important for anybody that's a lawyer right now that cares about these issues to think about the question that Nick just asked. Most judges are not responsive to the need to apply the environmental rule of law in time. And in large part, they're not responsive because they don't yet know the nature of the emergency. So that's a challenge that to some extent needs to be attended to by lawyers that are bringing the cases. And I say to some extent, because I think it's unclear what's going to happen in the future if we're going to be able to succeed in protecting the earth in terms of the application of the rule of law by judges. In the United States, as Julia says, there's a culture within the federal judiciary of rejecting this idea, this concept that is so straightforward under the Constitution, but I think is uncomfortable for the men mostly, and some women, uncomfortable that you would give the future generations a right to a life-sustaining climate. But that's the federal government. And of course, the state of Hawaii is a state jurisdiction, and it appears that there are other courts in the United States from different states that are not going to take the approach, the kind of protectionist rogue approach that the federal courts do, as I think epitomized by our United States Supreme Court in West Virginia versus EPA. We do have some magnificent dissenters, as you know, that we have to be supported at the Supreme Court level. But overall, I would say that, judges in the United States are not as responsive as they need to be, but they can become more responsive if we have more cases like our Children's Trust, not just because of the advancement of the doctrine, but also because it motivates young people. That is a force that's necessary for judges to start becoming responsive, because, judges are in a political branch, they're often political people. And if they see that it's becoming politically acceptable and maybe even important to protect children, and that's the hope that I have, that, eventually judges will see it's not that controversial to allow future generations to assert these rights, then things could move quickly. Because after all, the constituency that Julia represents is a constituency that's utterly non-controversial and completely a sympathetic constituency. It's not women, it's not minorities, it's not Indigenous people, who there seems to be a struggle to try to recognize as being in need of being treated in a just way in our world community. No, it's a different constituency. It's children, future generations. So that's what's so exciting about it, because no matter what your jurisdiction is, or whether you're a man or a woman, there is no controversy that these are innocent. They don't bear responsibility for the damage that's being done to their future every day. Therefore, I think that eventually judges could become more responsive if lawyers and young people step forward and make them feel more comfortable that they can recognize and protect these rights.
Thank you, Judge Wilson. Julia, do you have anything to add in our last minute?
Yeah, I think children are nonpartisan, and I think everybody values children. And so I think that's the doorway to have people who might have bought into the partisan stories around climate change, all the efforts to turn it into a political issue, when really it's a life issue. I think framing cases in terms of children's lives and health and security and safety, there's a lot of conservative judges in this country who very much want to protect life. And we may disagree about when life begins and at what point life should be protected, referring to women's reproductive choice. There's a lot of disagreement about that, but everyone agrees that once a child is born and they are breathing and living, that is a life that deserves protection, because they're at their most vulnerable point. They're developing, they're different from adults. And so, yeah, the climate rule of law needs to treat children specially, and judges need to welcome these young people and their claims of injury into their courtrooms and try to serve them as a really important part of our society and protect them and enforce the law on their behalf.
Wonderful. Thank you. With that grandiose and great ending, we will now, for the audience, turn to our closed door discussion with our community of practice. Again, if you are part of the community of practice, the link should be in the email for this webinar where the invitation was. And if you're not, you can email the email where the invitation came from, and we can add you to the community of practice, so you can be part of this now or moving forward. So I invite everyone to go back to your email and switch to the community of practice session. Thank you very much, both Julia and Michael, for being here. This was really enriching discussion, and I hope that we're left with some hope for what comes in the US and beyond. Thank you.
Melina, thanks everyone.
Thank you.